Good morning, everyone. This is a Canadian Immigration Institute live Q&A. I'm here with Alicia, and we might also have Mark, who's not in office today, but he will try to join the call and say hello to everyone. How are you doing, Alicia?
I'm doing well, Igor. Thank you for hosting. And as always, we're happy to hear where everybody's tuning in from. So Igor and Mark and I are all Canadian immigration lawyers. And this Q&A is here for everybody. And it's hopefully going to bring to light some issues that lots of people are facing. So we try to answer questions that are going to be of most general applicability. And so if you have something, if you've noticed something that's happened on your file, if you have things that are going to be important for other people to know, then please ask your questions. When to start off, you can post, so say where you are from and what you're interested in learning about today, and we will try to answer the questions that are going to be as broadly applicable as possible. So again, this is not immigration legal advice because we have to make sure that we are going to understand enough about your situation to be able to provide proper advice. So we are going to answer questions but not provide advice. If you do need advice, we're absolutely happy to talk with you. Just slide on over to Holthe Immigration Law and you can definitely book a consult. And that's where we can go through the specifics of your situation. What do you do? What are your options in this particular circumstance? But for now, we'll try to give you guys some great immigration information.
Yeah, and Alicia, I will admit Mark just right now. Let's see. How do I add Mark? Okay, it's probably this way. Okay.
Hey, I've replaced Igor.
We were trying to figure out how to add a third person, so we just figured we'd swap people.
Yeah.
All good. Can you hear me okay? There's probably a little bit of an echo, but whatever. That's okay.
Yeah,
It's
we
hard to
can hear
find
you
out a
fine.
quiet place.
Yeah,
Okay.
so a few things we wanted to talk about in the immigration world. There's been some changes. They've got some public policies, guidance that are being revised about intercompany transfers and CUSMA, so that's affecting things for a business immigration side. And then there's also, of course, the changes to the postgrad work permit eligibility. And so that's a big thing that has just been released. And so the guidelines are now online. And that's one thing that we'll go through in more detail today as well.
All right. Please let us know how do you hear us, because I see the comment from Marco saying that there is an echo. I'm not sure if that
Maybe
refers
it's
to,
my computer.
yeah,
It could be me.
okay. So I'm gonna stick in the background, but I will pull up some questions. So let's see. We have a shout out from Gurpreet, and Gurpreet is in Lethbridge. And Gurpreet is working in a motel. And let's see. So Gurpreet also asks any update regarding federal Tier 4, Tier 5 pathway. So that is the new program that they've talked about, that in the future they might create a federal immigration program for low-skilled workers. Do you guys have any updates about that?
Still no updates on that yet. Maybe it'll be something that they announce when they do the levels plans announcements in November 1st. So we'll have to see if they do announce a new pathway, or maybe they are going to try to funnel things to work permits for Tier 4 and 5 rather than permanent resident pathways for the meantime, but we will have to see. They did definitely hint at that, and we don't have any announcements as of yet.
Okay.
Yeah, it's so hard. Like when I think about this stuff, uh, like with their significant attempts to reduce the numbers of temporary residents, I'll believe it when I see it. I'll be honest. There is, for them to then create more pathways for low skill and low wage workers. I think it's quite unlikely that they're going to do that. I think what we look for is what the Alberta Advantage Immigration Program is going to do, especially if you're in Lethbridge, my friend, where I'm actually down in Utah right now. But I think that's something that we watch for probably, but anything can happen, right, Alicia? No one would have expected February the 13th of 2021 when they extended invitations to every single person that was in the pool who were eligible for CEC. So anything can happen.
Yeah. Yep. So try to make sure that you've got eligibility for whatever program you're looking at. Give yourself a few options if possible, because Mark's absolutely right. You don't know what's going to happen. If you're eligible, there are usually benefits in trying to put a profile in Express Entry just to see what happens with that. But of course, you've got to meet eligibility for one of the categories. So federal skilled trades, federal skilled worker, or the CEC.
Yeah. And we do have a very interesting question from Ninu that would be really beneficial to lots of viewers. So IRCC says you can work remotely for an employer outside Canada as long as you still meet the conditions of study permit. This type of work does not count towards your 20 hours in Canada. So how do we respond to Ninu in here? Like, what's the difference between working on a visitor visa and, let's say, working on a study permit for an employer outside Canada? Is there any limitation?
And so, Ninu, this, it's difficult to try to figure out what exactly your question is, but I think talking about what are the considerations that you're going to want to look at if you're in this situation. And the biggest question that I would ask you is, what are your goals? Because if you're here on a study permit and you're pursuing full-time studies, then one of the conditions on your study permit is that you maintain active, valid academic status. And so you're working towards completion of your degree or your diploma, you're getting good marks, you're passing your exams, you're attending your courses. And it's really difficult to work full-time, multiple jobs outside of Canada and inside Canada and study full-time. And so make sure that whatever you're doing, it has to be authorized if you're doing work while you're on here on a study permit, but making sure that you're going to meet your degree and graduation requirements. And of course, you cannot claim Canadian experience, high skilled experience for your work for CEC until you've completed your degree and you're no longer a full-time student. So just keep that in mind as well.
Yeah, Mark, do you have anything else to add in here?
Not really, just that this is nothing new. Like, it's not like IRCC has announced some change in policy. There's never been a restriction really on anyone who is working virtually. This is, in its very essence, it's the digital nomad concept, I guess, that's been extended. But, and this kind of parallels what Alicia said. My goodness, like, it is hard enough to succeed in Canada, you know, just attending school regularly and trying to get good grades. But you can imagine trying to work at the same time as going to school. I advise my kids this all the time. I've got one that's graduated, 3 that are kind of right in the mix for university, 2 that are attending right now. And the reality is you need to do as good as you possibly can in school to succeed, to get a good job when you get out of school. And if you're compromising that with, working an extended amount of time, really, like, you're just going to really struggle going forward. And the way that newcomers to Canada succeed is by separating themselves from everyone else and really doing as well as they can. So I always encourage people, if there's any way possible to focus, to be able to focus on your studies. That's, I think, for all intents and purposes, that's what IRCC, that's the messaging they're trying to get across now. All right, Igor, we got you in. Woohoo!
I was just quietly trying to figure it out. How do I add myself?
Yeah. So you're there. Perfect. But yeah, no, I just advise people, look, if you're coming to study and you can find a way to do it, just really work the very least amount that you possibly can, because in the end, your future depends on your success in school if you're an international student. And it's hard enough as it is to convince a Canadian employer that you are, on par with a Canadian or existing permanent resident. But when you add in kind of mediocre grades, well, you're almost setting yourself up for failure. So I'll leave it at that.
Yeah. And the other thing I'd add to that too, and this goes for people who are digital nomads who are here on a visitor visa and they're working for a foreign employer, make sure, same thing if you're on a study permit and you're working for a foreign employer, make sure that you are not inadvertently entering the Canadian labor market. Because if you are entering the Canadian labor market, if you're a student, that can count for your hours of work. Or if you're here as a digital nomad, you definitely cannot enter the Canadian labor market unless you have a work permit. And so making sure that if you are working for a foreign employer, all the clients are foreign, you're paid in a foreign currency to your foreign bank account, you're not displacing a Canadian in the job that you're doing.
All right, we have another question from Jon Snow. That's the one from Game of Thrones, but he's asking about his spouse. Can he add spouse at EAPR stage if the minimum score was 425, and then he qualifies that if he adds his spouse, his score will go down below the 425. So what are the implications of that?
So maybe I'll jump in on this one. The key here is that you were a spouse before you filed your EAPR. I'm assuming when you submitted it, and I think this is pre-EAPR, right? Can you keep it up, Igor, the comment? Ultimately, when you're in that type of a situation, your spouse was probably listed as non-accompanying. And if I'm reading this correctly, when you're adding, well, actually, I guess this is the question. Can we add a spouse? So maybe, okay, so I'm assuming then, do we assume that this is a new marriage then? Should we go with that? I think,
And
okay,
it might be a PNP if he's got a notification of interest.
Yeah. So I wonder, Okay, so let's approach it from a PNP standpoint. So the provinces tend to be a little bit more flexible adding spouses. The big issue that you first ask yourself is, okay, is this a spouse that I'm married to now when I submit my application, but I'm listing them as non-accompanying? This is in the world of express entry. So if you have a spouse in that situation that's already a spouse, and then you try to add them after, then they will recalculate the points and assess your spouse against the comprehensive ranking system to see if you meet the minimum entry criteria and the eligibility for your program. So in that case, if you're going straight into express entry, that can indeed result in your application being refused, because when you add the spouse, you no longer meet the comprehensive ranking system score in many cases that you should have had when your invitation to apply was achieved. But if we take, say, for example, the Ontario Immigrant Nominee Program, lots of times they draw these slots, at a certain range between, say, 460 and 480. And so sometimes people are sitting at 500 and they're like, oh, with my spouse, I'm at 500. But if I list my spouse as non-accompanying, then my profile drops down to 475. And therefore I have a chance at getting a notification of interest. Well, in those situations, the Ontario Immigrant Nominee Program has indicated that they're not too fussed about those things. If you then, after you receive the notification of interest and you want to pursue it, that you add a spouse. But every single case is different. And you have to be very, very careful when you're approaching it this way. Alicia, when I see people in this situation, we're in a world now where you may never get another second chance. And the reality is, if you're sitting at, say, 495 and you're trying to get a human capital priority stream draw, a notification of interest, and it's just not happening, and you're not high enough to get an invitation to apply through a general draw, then maybe you're going to try something a little creative because you have nothing to lose. As long as however you approach it, as long as you make sure, darn sure, that you're not misrepresenting anything, you're laying everything out honestly and forthright, then those types of strategies, going in, listing your spouse as non-accompanying to get your score in the right range, getting a notification of interest, not misrepresenting anything within your PNP application, getting a nomination, and then updating your spouse and adding your spouse after, it may be possible for that to work, but it is a very risky proposition, and I would only ever suggest that would be a viable option if you had no other option. And once again, letters of explanation, I would explain everything so that there's not even just a hint of a chance that they could say you're misrepresenting. So that's a kind of a long circular route. Alicia, what are your thoughts on this?
Well, what I worry about is Jon Snow's last comment, because their CRS is going to go below whatever the draw would have been if they do add the spouse. And there is a risk, absolutely, there's a risk that if you add the spouse and the CRS goes below whatever that bandwidth was, that OINP or whatever provincial nominee program says, too bad, you no longer meet the eligibility criteria. And so you might lose that nomination. And so if it is possible for you to continue your PR application, get your landing, and then turn around and sponsor your spouse, maybe that might be an option for you. And so anytime that, there's a lot of moving parts and there's only 2 lines of text here, make sure to book a consult and we can talk to you more about what application stream, what provincial nominee program are you looking at, what are the other factors, do you have other family members, where is the spouse, where are you? So all sorts of different things go into what should you do. We're just talking about potential options here.
Yeah. And I'll throw out one last caveat. If, Jon Snow, your spouse is already here with you in Canada, and you try to list them as non-accompanying in your express entry profile, if that's kind of the route you're going, understand that you could run into a situation of IRCC alleging misrepresentation. So lots of people ask questions to Alicia and I about whether or not they can list their spouse as non-accompanying when they're already here on a work permit. Under every situation, our first piece of advice is never, ever do that. And so I'm not going to get into the unique circumstances where you may be able to get away with it. But ultimately, that's something else that you guys have to be aware of. And we understand the situation. We understand how desperate people are, that the chances are just a sliver sometimes to get PR. And if you push the envelope a little bit on one, in one way, it may open up a possibility that you never would, have in the future. But please book a consult with us. Let us talk you through it. Let us back you off of the ledge. If you're in a situation where you're just desperate to do anything, that's what we offer in those consultations is specific legal advice.
Okay. So let's move on to the next question. I'm debating which one to pull up first. Maybe I'll go with Abdullah. So Abdullah is asking which one is easier, C10 or C11 work permit application to start the innovative business?
So C10 and C11 are very specific. It's based on legislation. And so they're looking at significant benefit. And there are different definitions of significant benefit. And some of those have to do with cultural or artistic or economic benefit. And those are all defined terms under the program policy guidance. And so it's not so much a matter of which one's easier, it is which one is the best fit given your type of business and the legislation. And so this is something that really requires a discussion in terms of what kind of business are you operating? Does it fit the definition of significant benefit for one of these pathways? And if you're not interested in the startup visa program, then yeah, you're looking at a different type of pathway under C10 or C11.
Okay. And then the next question is from Dan. So Dan is saying hello, and he's wondering if one has a valid closed work permit, but no longer is with the employer, can one use the closed work permit to submit an Alberta expression of interest application? So a couple of bells ring here.
Yeah, so Dan, first and foremost, and I think there might be some confusion about this, the Alberta expression of interest worker profile is not a separate stream. There's no new stream. It is just you have to fit within one of the regular streams already. So within Alberta Advantage Immigration Program, the big buckets are the Alberta Advantage, so AOS, Alberta Opportunity Stream, and then you also have the Alberta Express Entry. And within Alberta Express Entry, you have the tech pathway within that. And then there's rural renewal, and then there's other streams as well that have fewer numerical slots usually. But you have to meet the eligibility for AOS or Express Entry through Alberta Advantage Immigration Program, and then you're going to be having your expression of interest. And that's where they're going to take a look at what are your points. And if you're looking at one of those employer-driven applications like AOS, you have to make sure that you still are employed with that employer to meet eligibility criteria for the job offer. If you are doing a stream that doesn't necessarily require a job offer, then it might be a different situation.
Okay, and then the next one is kind of related because it also deals with Alberta. So I have a continued work experience with the same employer under postgrad work permit, implied status, and currently LMIA work permit, respectively. Thus, experience gained on implied status, is this experience valid for the hospitality stream? And just to remind, for the hospitality stream, you have to have an experience that you gained on the employer-specific work permit, and postgrad work permit is not the one. So do you have any other thoughts, Mark or Alicia?
Yes, I'm thinking that they went from PGWP to implied or maintained status. Then they actually do have, hopefully, an issued LMIA work permit right now.
Yeah.
And they're trying to probably meet their months of eligibility.
Yeah. And I think the time clock starts, excuse me, when the LMIA based work permit is received and you start working under that authority. So that's, as far as implied status, the implied status would have flowed from the postgrad work permit. So without looking at anything else, I would have to say that it probably would not count in this situation. But once again, it's hard for us because I know this is Sunita's like, can I apply, right? And whenever it's an I, if I was running the eCam here, I'd ring the bell and say book a consult, and that's what we'd recommend you do, Sunita. Because right now, if the implied status was the transitioning from your postgrad, waiting for your LMIA-based work permit, then that implied status would likely not be accepted by the Alberta Advantage immigration program.
Yeah, to be safe, make sure that you're meeting full program eligibility, which is having that employer in the eligible occupation, because there's got to be one of the listed ones for the Alberta hospitality stream, and prove that you did that on that employer-specific work permit for the number of months.
All right, we do have two questions. They are very similar, so I'm going to pull both of them. So one of them is from Ninu again. And Ninu is asking, if someone applies for a study permit before November 1st, but receives the permit after November 1st, do they still fall within the new rules of program eligibility for postgrad work permits and spousal open work permits? And then we do have a very similar one from Dan. If one applies for a study permit before November 1st, is there changes to the spouse getting an open work permit?
And maybe, I don't know, Igor, I don't know how much screen we have, but I think what we should do is go to the changes to PGWP eligibility criteria under who can apply. And what they're doing is following up from the announcement that was made with Minister Miller and Minister Boissonnault, and Mark and I had done a live watch party on that. And basically what they're saying is there's two kind of buckets of time now. And so what we're looking at is if you have applied for a study permit. So if you had applied for your study permit, you finished your program of studies, and now you're applying for a PGWP after November 1st. Igor, it's the one that I put in the group chat yesterday as well. But if you're applying after November 1st and you had a study permit issued before November 1st, then you're in the situation of needing to meet the new language requirements. So this is the one. So it says what hasn't changed and what are the new eligibility requirements. And so if you look, there's two buckets. So you can expand both of those tables. There's two options if you submitted your study permit before November 1st, 2024, and if you are going to submit your application for your study permit after November 1st, 2024. So for people who already have their study permit, are working on completing their program, and are now going to apply for their PGWP, you guys are in that first bucket, and that's where you just need to meet the language requirements. The next bucket is if you're going to submit your study permit, so you haven't even started your studies at your program yet, and the study permit will be submitted after November 1st. In that case, then IRCC has announced new changes, and these are related to the field of study. So Mark said he's also released a few things on social media about this, so he's noting that that's been posted. I think he's already posted that, so if you're interested to go check what's going on. Mark, maybe you want to jump in and say what you posted?
Yeah, basically, what I did was obviously I was on the road driving down here. They always do this, the Friday drop, right, when everybody is like not paying attention anymore. And so I wrote a quick little blog post, kind of summarizing what people need to pay attention. And like you said, Alicia, for people that are already here, that have not yet submitted their postgrad work permit, but intend to do so. And I think November 1st is that the cutoff date. I think they basically, it's just language. And my goodness, if you've gone to university or college in Canada and you can't hit the language levels that they have there, well, there's something wrong. So the first comment was simply, don't waste your time in school. And those of you who are working 40 hours a week, maybe that's a problem if you're in the back kitchen and you're not working on your English and not attending school. But the vast majority of genuine, legitimate students are not going to have a problem with this. The challenge becomes for people who have not yet submitted, excuse me, a study permit application, or, that's really what it comes down to. Then they're going to be in a situation where they have to hit onto these specific categories, these industries. And so that's going to start rolling out November 1st. We're October the 9th today. So I guess if people, if you want to have a little bit more freedom with your application, work like crazy and get your application to school in. Well, you're not even going to get your study permit, but it's submitted. The study permit submission is kind of the trigger. So do it before November 1st if you want to have a little bit of variety. But I'll be honest, ultimately going forward, when you're applying to school, one of the pieces of advice I gave was look at where the long-term shortages are. Because if your desire is to become a permanent resident of Canada, then you need to play by the rules. Figure out what they are, and then just knock those rules out of the park. Focus on programs that are in long-term critical demand, and you're going to have a far greater chance of then not only transitioning to a postgrad work permit, but ultimately finding a pathway to permanent residence. And that is where the rules are changing. So individuals who are already in the system, who have already even submitted their postgrad maybe and haven't got a decision yet, which is probably very few at this stage, you're fine. There's no changes. But those of you who are submitting your postgrad work permit while you're in school, and you're going to be doing it after November 1st, then it's just the language requirements. And then you need to have those done before you submit your postgrad work permit, which you haven't had to do in the past. You need to actually write a language test. So write it, because there's going to be a lot of people that are going to be, if you're waiting. And I think time-wise, when you look at when school's completed, we're into October here. And so probably most of the people that graduated in April have already submitted their postgrad work permits. But if you did summer session or something and you're in that stage where you haven't yet submitted your postgrad work permit, if you do it after November the 1st, you must have that language test written. So just be smart. And yeah, check out the X post. Obviously it got a little bit of traction. I think it's one of the larger X posts I've had. That it's got about 15,000 views, but go check it out. And we'll also definitely have some blog posts that we'll be dropping here shortly to pull out some more takes, because it's one thing just to parrot what the government's saying. It's another thing to provide tangible, real world, thoughts on what it means for you on an individual basis. And that's what we try to do here at the firm.
All right. Let me just revert back to the 3 people view. Okay. And get rid of the screen. Okay.
Well done. This is impressive. On the fly. This is really good. Good job.
All right, so we do have another question. So what is the probability the postgrad work permit holder can get a study permit again, and a spouse can get a C42 work permit when currently on C41?
So yeah, so there used to be a strategy of people saying, okay, well, one spouse is going to go to school, the other one will get an open spousal work permit, and then maybe, because you can only ever get one postgrad work permit, that first spouse is going to do something else, and then the other spouse is going to try to go to school. And so keep in mind I think it is highly unlikely that there will be these 18-month extensions. So the same rule that's one postgrad work permit and then you're done is quite likely going to be the case going forward. So if the other spouse is able to be eligible for a study program, maybe that's something that you pursue. We don't know yet. So what we don't know is they have said in their announcement on the 18th of September, there will be upcoming changes to which spouses are going to be eligible going forward. But we don't know exactly what those are. So all they've said is that, later this year, they are looking to limit the open work permits to spouses of master's degree students to only those whose program is at least 16 months in duration. So that's what they've said. So it really is going to depend upon what program you guys are taking a look at and who's going to be the principal applicant on these applications.
Right. I'm looking through other questions, trying to pick one. All right, maybe we'll put up this one. Okay. I applied for a Canada permanent residence in January 2022. Got the request for payments in March 2024, so 2 years after. And my friend's file moved from Sydney to Delhi to a different visa office. Do you think the payment request means that the completion of the permanent residence applications is close?
That's strange. I don't know what's really being asked here. My friend's file moved from Sydney to Delhi. Do you think the right of permanent residence fee means the PR is closed? Well, usually when they take a right of permanent residence fee, it means, that the application, traditionally, it's being approved, right? And I don't know, Alicia, if you've got any extra thoughts on this.
Yeah, and it seems like it's not an express entry file. It seems like it must be something that's under a PR portal file. So there are longer processing times, but hopefully if they have asked for the landing fee, then hopefully they are close to finalization. Oh, Igor, did we lose your audio?
Oops, sorry. So AK was wondering when should he apply for the bridging open work permit if his current work permit is expiring in January and he already submitted his PR application and got an acknowledgement of receipt as well.
Mm-hmm. And so AK, this is always the question is, are you in fact eligible for the bridging open work permit, or is there a reason why you might need to look at a bridging closed work permit? And so if you are somebody who had a provincial nomination, this is where you need to be super careful and make sure that you don't need to apply for a bridging closed work permit. So if you did a PNP program and it had an employer job offer that was part of your eligibility for the bridging or the PNP program, then you might need a bridging closed work permit. And that might be really important because you could lose your nomination and you could lose your PR if you no longer stay employed with that same employer. If it is not a PNP situation and you just have a straight express entry, then you're going to follow the rules for eligibility for a bridging open work permit past your submission of your EAPR and past receiving your acknowledgement of receipt.
All right, this one is very good question. So do you recommend Alberta Rural Renewal Stream? I just got a job offer and my employer is ready to support the endorsement. What are your views on this? I'm a graduate from Ontario.
That's a great question. Okay, here's how I approach every single person who asks these things. If you have one single option available to you, I don't care what it is, you're going to seriously consider it. If you have two, even better. If you have three, you're going to pursue all three. The only time it becomes an issue is if one undermines another. So you cannot realistically have a nomination application in process with Ontario and a nomination application in process with Alberta. And so if you have two nominations, or for example, a Quebec-based immigration program and a federal program in the queue, because each of the expectations is that you demonstrate intentions to, with the PNPs, live in that province. And if you already have another application submitted to another province, it can undermine the credibility of your statement. Oh no, I intend to live in Alberta, but I've got an Ontario nomination in the queue as well, and I'm just waiting to see which one wins. I'm not saying it's not possible, but it is a serious underminer of an application. And like with the Quebec-based programs, you have it to demonstrate an intention to live in Quebec, whereas for express entry, you have to demonstrate an intention to live outside Quebec. So those are the only real restrictions that you have to pay attention to. But with my clients, there was a time, Alicia and Igor, where I felt lawyers were not very good if they couldn't just choose the right program and pursue it with their clients, because there was always the best one, whether it was processing times or otherwise. But now with the volatility and everything, we have to treat immigration as kind of like a buffet. And it's not really a buffet, because buffet gives the impression you can choose programs and pick the best and the ones you like. No, you take every opportunity you can. And if it means you have multiple applications in the queue, you can do that. The only restriction is when it comes to sponsoring family, you can't have, multiple sponsorship applications in the queue. And that some people don't understand. But that would be my advice in this.
Mm-hmm. And the other thing is to keep in mind, so rural renewal depends upon a community endorsement letter, and every single community has its own process. And so depending on where you are going to intend to live and work, but you have to be in that community. And so you have to have a legitimate intention that you're going to live and set up your life and work in that community. And go through the website. Most of the communities have a whole page dedicated to how their process works. And it's important for the employer to understand what their obligations are as well if they're going to be pursuing that. So they have to do it usually employer application and then the community endorsement letter.
And maybe what else we can do here, just to make the answer complete. So we can go to the Alberta ANP website and see at the inventory how many applications are in the queue, how many invitations have been issued, and what is the likelihood of getting an invitation under one of the streams. So if you compare like rural renewal stream to Alberta opportunity stream in Alberta, the preference would go to rural renewal stream because the province is trying to invite more people living in rural areas. And even if you look at the points grid in the expression of interest, so endorsement letter from a designated community in rural renewal stream gives you extra 6 points. So if you're choosing between different provincial nominee programs in Alberta, rural renewal stream probably would be one of the best options in here. Do you have anything else to add about this, Alberta, Mark or Alicia?
Okay. No, nothing there.
All right. So then let's tackle this next question from Nino. As a digital nomad in Canada, can an independent consultant working for a foreign country, for a foreign company, receive his pay in a Canadian bank account in Canadian dollars? Again, not entering Canadian labor market, no Canadian clients, foreign company. Do you have any concerns with this?
Okay, I'll let Alicia answer this one. This is near and dear to her heart.
Yeah. So, Igor, maybe you can pull up in the operation manuals the definition of work. And so this is something that is a very broad definition. Under the Immigration Act and the Refugee Protection Regulations, they are looking at a very broad definition of what work could be. And it could be anything for which wages are earned, commission is paid, or that is going to displace somebody from the Canadian labor market. And you're starting to tread on very thin ice if you are doing something that IRCC could say is work. So Regulation 2 says, yeah, here we go, it's pretty small. Activity for which wages are paid, commission is earned, or that competes directly with activities of Canadian citizens or permanent residents in the Canadian labor market. And then they talk about what wages or commissions are. Then they talk about what activities are that compete directly. And then they give examples of work that, it's not an exhaustive list. This is just things that they consider could definitely be work, and then things that they consider may not be work. And it's pretty restrictive in things that are definitely not work. So you do want to be very, very careful. And then even if you get a legal opinion and you're sure that you're on side from an immigration perspective, you're also going to want to go get some good tax advice. right? Depending on what your country of nationality is and Canadian tax advice, you want to make sure that you are properly filing tax returns and remitting taxes if whatever you're doing is now going to cause that to be considered to be Canadian earned income. And as soon as you have Canadian earned income, that's probably going to be an issue from an immigration standpoint, maybe. So a number of things that you'll want to be careful with if you're considering getting paid into a Canadian bank account.
All right, and then we do have another super chat from Tanvi. Let me just switch back. Okay, so Tanvi is asking this. Under what circumstances can a recent Canadian permanent resident who immigrated under a French category move to Quebec? Would it be considered as misrepresentation? Would it pose any challenges at the time of citizenship?
Mm-hmm. And
We've,
so,
we've heard this one before, haven't we? About 5,000
Tanvi,
times.
yeah, Mark and I did a whole podcast about this. And so if you go into Holthe Immigration Law and you go to our resources, you will be able to link down, or you'll go anywhere where you listen to your podcast and you look for the Canadian Immigration podcast, then you'll be able to see our recent episodes. And one of them was all about intention to reside. So Igor's pulling it up here in the background, but we have a whole podcast dedicated to intention to reside. And I forget exactly what we called it, but it was recent. We did it within the last month or so. Basically, any time where you have told the government, I've come under express entry, I'm not going to live in Quebec, then you have to show that you have a valid intent to live anywhere other than the province of Quebec. If you then turn around and right away go live in Quebec, then for sure it is a risk of misrepresentation. It's a risk that they can take away your permanent residence based on you not being genuine, you not having a valid intent to live somewhere other than Quebec. And it could be something that comes up when you do your PR card renewal. It can be something that comes back to haunt you when you try to do a citizenship application. So for sure, and there are cases out there, and there's case law that we talk about in the podcast as well, that talks about this intent to reside. So definitely you want to make your best go of living anywhere other than the province of Quebec. And if after some period of time you've shown best efforts and you really can't make a go of it outside of Quebec, then at a certain point, mobility rights kick in under the charter. And depending on your situation, it's up to you to justify that that was a reasonable action that you took.
Yeah. And just to reiterate, there is no line that if you cross, then you're safe. There's no line that says you have to stay in a particular province for any given period of time. But what they're going to look at, as Alicia indicated, is the objective intention. Essentially, if someone was to look at your situation, because no one can get into your mind, right? Look at your situation and say, well, did this person really have an intention at the time in which they became a permanent resident to reside in this province? Then, okay, fine. If the answer is yes, then there is no temporal restriction on when you leave. But the sooner you leave after arriving in a province, the more difficult it's going to be to show that yes, my intention was genuine. So we always advise our clients to be very, very very conserved, I guess, in terms of how long they stay in provinces. Really give it a good try. If you've never even set up any kind of a lease or anything like that, and you're just staying at a bed and breakfast or a VRBO or some temporary stay accommodation, and you never actually make an attempt to secure, say, a longer term rental, I think that's a pretty big indicator that you don't really intend to settle in that province. I just use that as one factor. Or if they go back through your phone and they see that you've had discussions with a company in Quebec before you became a permanent resident, and you'd already accepted an offer to work for them, and it's not a virtual position, well, obviously, those types of indicia, I guess, are going to point the scale to maybe that intention wasn't there. But Alicia, when it's all kind of coalesced and collected together, at this stage, I've never seen anyone um, lose their citizenship over this issue to this point. But I don't want to be the first one to have a federal court case on a client of mine that I advised they could just go to Quebec the day after they became a PR. Like, I would never ever do that.
Yeah,
Are
and
you aware of it?
there are cases out there, and it's less on citizenship determinations as far as I
Yeah,
remember, and more on the PR
yeah,
extensions.
yeah. Unraveling it. Yeah.
All right. The next question is also interesting. If a student has completed their studies, got a 3-year postgrad work permit, can they repeat the cycle again?
No.
No, and this is exactly what I was saying earlier, is that postgrad work permits are one and done. When you have completed your program of studies and you apply for a postgrad work permit and are issued it, that is it. That is all. It is over. It cannot be extended other than what's called a recapture of time. If you did a 2-year program and you were eligible for a 3-year PGWP, and the only reason they gave you, let's say, a 1-year PGWP was because your passport was expiring, you can do a recapture of time to get back the rest of that 3-year term that you should have or would have gotten had your passport been valid. But other than that, there is no extension. There is no way to get another postgrad work permit. You can't go back to school and then come back and get another postgrad work permit again. Once you have one, it's done forever. And so this is also why it is really important to be strategic now. So as of November 1st, 2024, pick your programs carefully. Make sure that you are attending a reputable school, something that is a designated learning institution in a province that you think you're going to have a pathway to PR for. So make sure that you're being strategic about going to provinces that are less populated, that have better, more provincial attestation letters, better chances at getting into that program. And then look at the program within your DLI, make sure it's postgrad work permit eligible. And if you are now in your after November 1st, 2024 world, you're going to have to tie that field of study to something that's going to be in an in-demand long range occupation if you want to get that postgrad work permit. So language and field of studies that are going to be in demand. So, this is no longer just any sort of program will do. If you want a postgrad work permit, you've got to do something under that program that's going to be a long-term in-demand need in order to be eligible for your PGWP.
Exactly. Okay, so we do have 2 messages, one from Janvi and one from Ninu. Both say thank you for all the answers that we provide in this live Q&A. I'm just trying to be a host, an administrator for this live Q&A today. So those thanks go directly to you, Mark and Alicia. So the next question is
Igor,
also...
it wouldn't happen unless you were hosting, so kudos to you.
It would not. No. It's a bright, sunny day here today.
All right. Okay, so Ryan asks, can a person change employers and or city once the rural renewal stream nomination is granted? Uh-oh. PR application has been lodged. Thank you, guys.
Okay, let me jump in on this. Okay. I don't know you, Ryan. I don't. I don't know the other person who said, hey, can I move to Montreal? But here's the reality. There's the law. There's the spirit of the law, I guess. And then there's the letter of the law. And I'll be honest, I don't even entertain those questions. Because what you're asking, at least on the surface, appears to be, can I just use a poor little community in Alberta, and I'm a rural kid in Alberta. So can I just use a poor little community in rural Alberta, get my nomination, get my permanent residence, and then get the heck out of there? Can I go back to Calgary or Edmonton that are not a part of the rural renewal stream? The whole purpose of these programs is for these communities who are seeing their numbers shrink, get people to come and live in rural Alberta. That's the whole purpose of these. And I know I need to be kinder, but the reality is it is an abuse of that process if you're just using it and have no intention. In fact, it's misrepresentation. You're not only lying to IRCC, but you're lying to the community if you have no intention of living there. So I'll say that. Now I'll qualify that, okay? People's lives change. Circumstances change. Businesses that you got a job for, maybe they're awful and you thought it was going to be a great solution for you and your family, and then the owner treats you like garbage. There is no, just like the charter offers freedom of mobility there across Canada, you have the ability to move. You do. But my only hope is that there are hundreds, I would say hundreds of thousands of people that would give anything for that little nomination to Wetaskiwin, Alberta, to live there and become a permanent resident of Canada. And so please, if you don't have any intention of using it, then don't take that spot from somebody who would. And now I'll turn it over to Alicia, who has much more level. I tend to be a little volatile.
So what I would say is a counterpoint to that, and I've had some consults with people who are in a really tough spot because their employer initially supported them through a PNP program that required an employer job offer and the employer declaration and the whole thing. And they've been working for this company for years. And then now that their postgrad work permit is expiring, they have to go and apply for a bridging closed work permit because it's an employer specific restricted nomination and they're applying for the bridging closed work permit. Well, now all of a sudden the employer was worried about filing this application through the employer portal because they're worried about what their compliance requirements are. And now they're going to drop this employee on their head. And the employee is super stuck because once you've submitted a rural renewal stream or another employer specific PNP application and you submitted the PR stage, you are tied to that employer. And so if the employer drops you for some reason, you're toast. Everything's going to fall apart like a house of cards because the province is going to withdraw their nomination. Your PR application is going to get refused if your employer fires you or if your employer will no longer help you continue to be able to get a closed work permit through the employer portal. And so I feel for people who are in that situation through no fault of their own, the employer starts to get cold feet and they're worried about compliance or they don't know how to file the employer portal or something like that. So if that's the situation and you're stuck, things like that happen. So, reach out. Sometimes employers just don't understand what their requirements are and they don't understand immigration. Book a consult. Have your employer book a consult. We're happy to talk to employers and say, look at here's what the act and the regulations and the legislation says. Here's what you're signing on for when you're getting involved with employer declarations from a PNP or when you're filing an employer portal offer of support or when you're doing an LMIA.
And I guess the last little piece, just to wrap it up, and some employers just have no intention of supporting you for PR. They have policies that they just don't do it. And I won't speak to why those policies exist, but before you ever take a job with any of these companies, do your due diligence as much as possible. Try to determine if they have a history of supporting permanent resident applicants or whether they have a policy internal that's just a flat out no unless you're maybe at a certain level. So just be careful, do your homework, and because it's far better to choose never to work for a company if you have options that doesn't support PR than to work and spend a whole year burning up your postgrad work permit or other work permit only to realize that critical component that you need from them, that little tiny piece of support, even for the Alberta Advantage Immigration Program, is not there. And then what do you do, right? That's the hard part.
All right. As we talk about the rural areas of Alberta and Canada in general, I want to pull up the question from Nikisha. So she asks, does the LMIA for low-wage stream closure affect persons in rural areas?
So it comes down to the unemployment rate to start with. If it is 6% or higher, even if you're in a rural area, then that's a subject to the exceptions in certain industries, which may apply even in that situation. Then your employer just can't get one. But remember, the caps, the percentages are still there. And for most low wage, it's 10%. So if you're working for an A&W in, Lloydminster, Alberta, and that there are over half of the employees in that franchise that are foreign workers, not permanent resident, but foreign workers, and they're on labor market impact assessed work permits, know that it's going to be pretty much impossible for that business to secure one for you. And it's hard because you're in a vulnerable position because you just don't know. And sometimes employers, the ones that are not great, will kind of lead you on to get you to stay and work and then kind of drop the ball after and say, well, oh, shoot, sorry, now we can't get the LMIA. And there are some really awesome employers out there who are very honest and open with you. And yeah, at the end of the day, those are basically the two factors. I don't know, Alicia, if you have anything more to add.
No, I think that's a good summary. And I sent a link there, Igor, and the reason I did was because I'm looking at the comments from VJ Shaw, and I'm also looking at the comment from Julio Manriquez. And I want to circle back to the fact that almost nobody can apply at the port of entry anymore for work permits. And so please take a look at this link. It's the program policy manual on who can apply at a port of entry. That covers land borders. It also covers airports. So almost nobody, especially on a PGWP, there is no more possibility for people to apply for a postgrad work permit at a port of entry. Know that because that's important. The next thing is it is very, very, very risky unless you fit all of these specific legislative requirements to ever apply for a work permit at the airport. And so there are only very specific cases where people could be eligible to do that. So take a look, Temporary Foreign Worker Program, TFWP, International Mobility Program. It covers both persons who may apply at a port of entry. So take a look at that, Julio, for your situation. And for VJ, Mark and I are talking about in our Time's Up series podcast, what are the options for people who are running out of time? And so we have definitely heard people who are filing PGWP extension applications that they know are going to be doomed to failure in an attempt to get extra months of time. And this may not be your best option. And so Mark and I are doing a whole Time's Up series about what happens if you are in this situation where your postgrad work permit's expiring, you can't get your invitation to apply under express entry, things are super, super competitive at the provincial systems. And so what do you do? And so we're going to go through a whole series of what people's options are. And in some cases, in order to preserve your best pathway to economic PR, the best option might be to go home and to get that foreign work experience and to get more points on your express entry profile. You can carry forward your Canadian work experience for within the last 3 years from when you put that application in. So we're going to talk about all this. We're going to talk about extensions. We're going to talk about restoration. We're going to talk about transitioning to a different type of work permit if that's available to you. We're going to talk about, what happens if you do have a legitimate relationship with a Canadian citizen or permanent resident? Is a spousal sponsorship potentially an option? What if you've come from a country and now you have humanitarian and compassionate considerations? If you have children, especially best interest of the child, or these situations where we're hearing about, there's more refugee claims being made, and there are real risks about making a refugee claim if you have delayed and gone to school. And but there's also situations where the world has changed in the last 3 years and your country might be in significantly dire circumstances, but you also have to be personally targeted if you're looking at a refugee claim. So there's a whole bunch of things. Mark and I have heard many stories of people who are now trying to face this difficult decision of what do we do now because the permit's expiring. So we're definitely going to roll out more podcasts on that very issue.
And Alicia, on that note, I cannot resist but pull up this comment. You're gonna love this one.
Aw, thanks, guys.
All right. There is one question that is really important. This one is from Daniel. So he says he meets the eligibility criteria for Alberta Tech Pathway, but the employer is not in operation for 2 years or more. Does that qualify him? And I want to...
Oh, Igor, did we lose your audio?
Yep, you did.
Okay.
Now the audio is back. Okay, so this is the page that directly targets the question. And Alicia, I'll leave it to you, but I'll scroll all the way to here.
Yeah.
I think it's this paragraph.
Yeah. So this is where we've got the general Alberta employer. Thanks, Igor. It's really small. So the employer has to definitely be incorporated for at least 2 fiscal years. So that is their corporate year end, which may not correspond directly to, January to December or what have you. So take a look at the company. And Igor, did you say that the company has not been in business for 2 years?
Yeah, so the employer is not up to 2 years in operation.
Mm-hmm.
And
And
then
so,
Alicia, maybe I can also put it here, like, and highlight this paragraph as well.
yeah. Yeah. So, Daniel, if your company for sure has not filed 2 years of corporate tax returns, so you're going to look at the incorporation date or talk to your employer about what date they were actually incorporated as a business, and then what was the date that they actually have filed corporate tax returns, because sometimes companies will have what's called a shelf corporation, but it's not active, and then they don't actually have employees, they don't have payroll, they don't have earned income, and you have to count from whenever they actually have started filing corporate taxes. And so that is the date where you're going to have to make sure that the company has for sure 2 years of operation in Canada in order to qualify. I've talked with a lot of people who sometimes have, related companies. And so they have one company, but they have a separate sister company, or they have a parent company, and maybe they were hired under one company, but maybe they are thinking about being transferred to a different related entity because that other entity has more years of operation. But this gets pretty complex, and you've got to make sure that you're doing it properly, that there's no misrepresentation, that you're properly claiming the work experience with an eligible employer. So this is where it's really important to do your homework, do your due diligence to make sure that the employer is going to qualify before you try to pursue any sort of application under AAIP.
Yeah. And Alicia, as we are already 5 minutes in the overtime, I propose that we take one last question. And this one is from BMC2. Will the new postgrad eligibility affect the students who are already in class?
Okay, and so this is where maybe, Igor, you can go back to the main page that talks about the changes to postgrad work permit eligibility criteria. And so this is where what hasn't changed is that you still have to be at a DLI, you still have to be eligible in an eligible program, and meet the general eligibility criteria. So if you are a current student, what will change is that after November 1st, you need to submit language test results, and those have to be valid. Um, but if you're a current student, and so this is where you look at what was the date that you submitted your study permit application. So if you're a current student and your study permit application was submitted, you are here on a study permit before November 1st, then the only new thing is that when you go to apply for your postgrad work permit 1 year or 2 years from now, then that's where you're going to have your language tests. Where you're going to have that new requirement of, and yeah, Igor is highlighting, you said no more than 2 years old, right? Yeah. So where you will have a change in what kind of program is going to be eligible is if you're only starting to apply for your study permit after November 1st, 2024. So for current students, you just need to worry about the language test. For future students, so people that don't have their study permit submitted yet and don't have it don't have a study permit yet, those people then have to deal with the field of studies as well.
All right. And so I'm going to pull another very important question. May I know when is the next live Q&A session? And that's a good segue to wrapping up this live Q&A for today. So the next live Q&A session will happen at the same time at 10 a.m. Mountain Daylight Time on Wednesday. And we do those live Q&A sessions every single week. We try not to skip those. If Mark is not available, I'm hosting the live Q&A. If Alicia is not available, I'm joining Mark. So it's maybe we can shift and do live Q&As, all three of us. But like we don't know. But what we know for sure is that it's going to happen every Wednesday. So on that note, I propose that we
could also remind them as well, Igor, that every other week, Wednesday evening at 4 p.m., we have our Express Entry Masterclass, which is it's kind of like a Q&A on steroids. It's like specific targeting of Express Entry. And those who subscribe to the Express Entry Accelerator, which is lifetime access to this, lifetime access to coming back to master classes, it's a little bit different because it's more of a Zoom kind of environment. So people can actually get on, they can ask their question, they can turn their camera on, and it's really an intensive. The course itself is so full of information. Usually, the answers that I provide are already in the course. But if there is something that's just really unique, really tricky, then it comes up in the masterclass. Everybody learns from everyone else, and that happens every other Wednesday. So not today because I'm away, but next week we will do that. We'll do that again, and yeah, I love doing this thing. This course has been around. It's in its 4th or 5th edition, and we're actually, speaking of steroids, we're actually looking at infusing some AI into it, which Igor and I are working on. And it's going to make the course just phenomenal. So anyone who purchases the course now even will have access to the upgraded version, which we do every time. So
yeah, and you will find a link to this course in the description under this video. So yeah, that's about it for today then. Thank you everyone who joined. Thank you, Mark and Alicia, for answering those tough questions.
thanks,
and
Igor.
yeah, for those who want to ask their questions and have not had a chance to get their answers, again, please join us next Wednesday at 10 a.m. Mountain Daylight Time. And I will say goodbye to everyone and turn this off.
Sounds good.